So it is a great honor, and I'm super excited to announce our brand new product under our current brand, NeX Protect, in partnership with WealthMax Estate Planning. Now, a disclaimer for everyone that WealthMax Estate Planning is not FCA regulated, and NeX Protect's FCA regulation is only for protection and insurance products. And NeX Protect is not FCA regulated for wills and estate planning. So, first of all, what is a will? Now, will is a legal document that sets forth your wishes regarding the distribution of your property and the care of your children once you're gone. Now, if you die without having a will in place, what happens is those wishes may not be followed. And furthermore, your loved ones may be forced to spend additional time, money, and emotional energy to settle your affairs once you're gone. Now, in different scenarios, if you don't make a will, for example, if you're a married couple, without a will, if you have children, your spouse cannot inherit all of your estate. And if you're unmarried couple, you and your partner, you're not married, unless you have made your will, your partner will get nothing. Your entire estate will pass to your children. And if you don't have any children, it will be shared between your brothers, your sisters, and your parents. And if you're separated, so let's say you're not on good terms and you're separated, if you die without making a will and you were married before, your spouse will be entitled to claim part or all of your estate because you don't have a will in place. Now, especially when you have children, if you have children, through a will, you can decide, you can appoint the people you trust as the guardians for your children. There is a possibility that children could end up in care with social care, while the court appoints a guardian of its choosing because you didn't have a guardian in place because you didn't have a will in place. Appointed trustees, you can appoint trustee through a will to manage all the assets you have, which your children will inherit, but because they are minors, you can decide who will look after your assets and at what age they will be transferred to your children. Now, so what is an estate? When we say wills and estate planning, what is an estate? Now, estate is literally everything, all the assets you have, such as cash, your business, your property, your farms, your policies, or your chattels. Now, what will be the value, or how will be the value of your estate be calculated? So all your assets minus all your liabilities, such as credit cards, debts you have, the mortgages which are pending. So this is how the value of your estate will be calculated. Now, there are different roles in will, such as executor, you have guardians, and then trustees. So let's go through all of them one by one. So what is an executor? When someone dies, the executor named in their will ultimately has to ensure that the deceased estate is properly wound up and their wishes in their will are carried out. So executor is a person who executes all your wishes when you're gone. Now, there are many legal responsibilities as well, such as sorting the deceased finances, such as paying any inheritance tax if there is, keeping estate accounts, arranging the funeral, distributing the estate, registering the death, such as applying for probate, things like valuing the estate. All of that is a responsibility of an executor. Now, the next thing is guardian. Now, there are a few things to consider when it comes to nominating someone as a guardian. Now, guardians, they will be the parent of your children. They will take the role of being parent to your children. Now, failing to name guardians in a will means that the care of minor children will be decided by the court. It is best to consider the age of the guardian and to appoint more than one because life is very uncertain. It should be made certain that the persons named who will be responsible for bringing up the children are willing to do so. Their consent is also very important. Now, financial provision should be made as well to enable guardians so they can raise your children once you're gone. Now, guardians should also make a will themselves to further safeguard the children, the future of the children, because again, if I have kids and I have someone as a guardian, if I'm gone and if they are gone as well, I want someone to look after my kids rather than court deciding that who should look after my kids. So guardians should also have further their will to make sure that they safeguard the children. So what are the trustees? Now, trustees are the legal owners of the trust property. Now, they are legally bound to look after the property of the trust in a particular way and for a particular purpose. Now, trustees administers the trust and in a certain way, in certain circumstances, and they make decisions as well. They make decisions on how the property in the trust is to be used. Now, the trust can continue, even the trust might change, the trustees might change, but there must be at least one trustee, even though the document will require usually two trustees. Now, if in a typical scenario, if it's a standard will, let's say Bill and Vera, a couple, and they have 4 children, John, Sharon, Alex, and Kate. Now, when Bill and Vera were asked, not advised, they straight away suggested that if one of them passes away, they want everything to pass over to the second person in any of the surviving partner. And then if the second partner also passes away, everything should be passed over to the children. Now, that's a standard will. And Valtmax Estate Planning Limited, their advisor advised Bill and Vera to have trust in place because they explained them the threats because of not having a trust in place. On the death, Bill settles his $250,000 estate into a discretionary trust. Now that trust is for the benefit of Vera, the 4 children, their issue, and the remote issue. So John, Sharon, Alex, and Kate. Now let me walk you through different scenarios because there was the trust in place. How did that trust protected against different threats? So let's say when Bill passed away, Vera got married. Now the question is, how much of the trust fund is attackable by the new husband? The answer is 0 because everything is in trust. Another example, let's say, how much of the trust fund is at risk if John, which is one of the kids, gets divorced? If John gets divorced, nothing can be affected. 0, because the entire estate is in trust. Just one more example. Let's say if Sharon went bankrupt. Now, Sharon is one of the kids. If Sharon goes bankrupt, how much of the trust fund is at risk from Sharon's bankruptcy? The answer is 0. Another example, let's say if Alex receives disability benefits, how much of the trust fund impacts on Alex's disability benefit entitlement? The answer is 0 because the entire estate is in trust. Another example to understand, if Alex goes into care, how much of the trust fund is at risk from Alex's care fees? The answer is 0. So all those threats. Another example, so imagine if Kate receives any benefits, how much of the trust fund impacts on Kate's means trust test benefit entitlement? The answer is 0. Another threat, just to understand the concept, imagine if Kate dies, how much of the trust fund is Kate's estate for her inheritance tax or IHT? The answer is 0. Now that was incredible, and all those threats were explained to the customer, and customer decided to have the trust in place. And this is why their estate was protected against all those threats I just explained. Now there's one more thing I want to cover today, which is LPA, lasting power of attorney. Now what LPA is? LPA means that you give someone authority to act on your behalf or take decisions, financial decisions, or decisions regarding your health and welfare when you can't make those decisions. Let's say, such as mental capacity, losing mental capacity. So let's say if John loses mental capacity, as an example, and he has not appointed anybody to act as an attorney on his behalf regarding the finances and health and welfare. Now his wife, which is Lisa in this example, and 2 kids, Max and Lucy, they would wish to take those decisions on John's behalf, but they can't because they have no legal right to do so. Another example. Now, before I give you another example, the question is who will make those decisions or take those decisions? Medical professions and local authority will make the decisions regarding the health and welfare, and Lisa, the kids, have no legal right to make decisions on behalf of John, because John did not have LPA in place. And imagine, even if, when it comes to financial affairs, even if John and Lisa had a joint bank account, now British Bankers Association says if one joint account holder loses mental capacity, banks and building societies, they can decide whether or not to put a temporary restriction to only allow essential transactions, which can make things more difficult than they already are because of John losing his mental capacity. Now, to gain, so let's say John lost his mental capacity. If Lisa wants to gain that legal right, she will have to go through courts. So what is involved and what are the costs incurred in applying for deputyship or having that LPA in place after John losing his mental capacity? It can cost about £5,000 for Lisa to arrange that LPA once John has lost his mental capacity. But if you had that will in place with an LPA, that would have saved all this money and the hassle Lisa will have to go through. So that's the solution, having lasting power of attorney. Now, it's a legal written document which appoints someone to act on your behalf when you can no longer make those decisions. It allows you to choose exactly who you would wish to make those decisions on your behalf in the event that you can no longer do so. Just to give you another example, and who can become the attorney, such as, well, there are a few conditions. They have to be over 18. It can be your spouse. It can be your partner. It can be a family member. It can be a friend. It can be any professional, but they should have the capacity to make those decisions and they should not be bankrupt. Now, who's the donor in this example? Now, donor is the person who makes that decision and passes that authority to someone. Now, you can have sole attorney, or you can have replacement attorneys, or you can have more than one person as an attorney. So donor is the person who's giving that authority to make those decisions, such as property, financial, healthcare, welfare. All those decisions will be made by that person who is given that power of attorney. Now, if you have one LPA, sole attorney, that person can make decisions on your behalf. They can solely make those decisions on your behalf. If you have more than one attorney appointed together, they all have to make those decisions together. But if you have one attorney in place and a replacement, if for whatever reason, once you are not in a position to make those decisions on your behalf, and first person or that sole attorney or the first preferred attorney you had in your LPA, if they're not in the capacity to make those decisions, then it can be passed over to the next person. Now, being an exercise IBO is a great product for you to share with your friends and family members and help them to get their will in place. Now, even though it's a one-off product where you acquire a customer once, but your BV will be allocated for the period of 3 months. And that's an incredible service. We have 4 different plans to make sure that your customers can choose according to their needs, what exactly do they want. We have bronze plan, silver plan, gold plan, and platinum plan. Now, there are prices for single customers if it's just for yourself, but if you're thinking of getting that package for yourself and your partner as a joint 2 people cover, then what happens is you get better prices. For example, on bronze plan, if it's a single package, you pay 149 as a customer and your BV will be 22 as an IBO, which will be allocated for the period of 3 months. If it's a joint bronze package, customer pays £249, which is a savings of £50, and your BV will be 35 for the period of 3 months. On silver plan, $299 as single, 45 BV for the period of 3 months. Joint on silver will be $499, saving about £100 and 75 BV for the period of 3 months. Gold and platinum, you don't have to, your customer will not pay upfront. Actually, they will be able to consult with our partner, WealthMax Estate Planning Limited, and their advisor will contact your customer, will help them understand gold and platinum packages and make sure they get the right package for themselves and give them the advice they need for them to have their will in place. So gold single is $399, joint is $749. which is again about £50 savings if you go as joined. Now, single BV will be 60 for the period of 3 months on gold, and joint will be 110 for the period of 3 months for gold. Platinum single price for single will is 749, and the BV will be 110 for the period of 3 months. And joint, you're saving about £500 to £600. You've only paid $9.99, and you get the BV of 150 for the period of 3 months. And that's an incredible opportunity for you to build your business and help your loved ones to have will in place. Now, I'm going to walk you through the process. If you can see my screen right now, this is NeX Protect's website, nex-protect.co.uk. We have a disclaimer here which clearly mentions that NeX Protect is a registered company in England and Wales under a company number 933269. Now, NeX Protect Limited is authorized and regulated by Financial Conduct Authority, but remember, only for insurance and protection products. Now, wills and estate planning services are provided through WealthMax Estate Planning Limited, which is not FCA regulated. It's an important disclaimer, and we want each and every single IBO to understand that and make sure that your customer reads through this information and they are aware of the disclaimer. Now, this is our website. If you click on get a quote, it will ask you if your customer is interested in life insurance, which is FCA regulated, or wills and estate planning, which is not FCA regulated and provided through WealthMax Estate Planning Limited. If I click on get a quote, it will tell me that there are it's a simple 4 steps process, and these are the 4 different packages: bronze, silver, gold, and platinum. Make sure that your customer is aware that on bronze and silver plans, you will have to make upfront payment, and our partners advisor will contact your customer within 24 working hours to make sure they can give them the advice your customer needs. For example, if I click on, so you can choose if it's a single or joint, and if I click on sign up on bronze plan, it will ask me for IBO business ID. Please make sure your business ID is entered correctly so you can get the BV allocated. Now, your customer details, and your customer will be making the payment. All the terms and conditions for wills and estate planning are here. Your customer will have to tick these 2 boxes before they can submit their order. Now, if I go back on silver plan, it's exactly the same thing. You can choose single or joint. You click on sign up, and you will be able to place an order. Now, gold and platinum package, your customer will not have to make the payment. In fact, they will get the chance to speak to the advisor before they make their decision. So make sure that you start approaching your friends and family members, walk them through the website, and help them have their will in place. We will be making impact on people's lives by helping them understand how important it is to have will in place. So let's educate our customers.